assumption that Kashmir and Jammu were not integrated. Even earlier, even in Iyengar's speech, the waiting is for accession, whether they ratify it or they don't ratify. But once they acceded, they became Indians. And in fact, even before the Indian army, when the facts are this, even before the Sikh regiment reached Srinagar, it was the Kashmiris of the valley who fought the intruders, and many of them were martyred. Mir Maqbool Sherwani is only one name. He was strung up and crucified as an example by the intruders. Hundreds of them not cross over. It's heroism beyond belief. So we're not waiting for them to integrate anymore. Now, at the point of that, at the point of accession, aside from when the Maharaja yielded, how much sovereignty he retained, whether his pact is enforceable or not as a fact between two sovereigns of whom one was subsumed, is a different matter. I'm saying there's a democratic argument to be made of shared sovereignty. At the point of accession, because political sovereignty vests in the people of Jammu and Kashmir became sharers of Indian sovereignty as political sovereigns, and your lordships have recognized the theory that political sovereignty is entrusted to the legal sovereigns, and the Constitution is an embodiment of that. And your lordships have recognized in the Indira Nehru Gandhi case that this legal sovereignty, it's a medieval concept to call it indivisible. It is essentially divisible. The nation state is an association of associations, and sovereignty, legal sovereignty, spread over various units. Of course, that case was considering the legal sovereignty as distributed among the three organs of the state. But the principle is equally applicable to the divided sovereignty between the center and the states. Because long ago, much has been said about the dual polity. I don't have to repeat it. So what Article 370 recognizes is the mode of government. It is the shared sovereignty of the people of Jammu and Kashmir, the merging of their democratic will with that of the rest of India. So in that sense, there is a democratic pact which has become part of Article 370. It has a constitutional recognition and guarantee. And that is quite aside from whether the Maharaja's pact with Mountbatten is enforceable or not. There is a democratic principle behind it. The historical and geopolitical background of a democratic coming together of people's will. The will of the people of Jammu and Kashmir meeting the will of the rest of the Indians. It was really a democratic urge, and many have spoken about it, how they chose India over Pakistan, although they were not given the choice of a plebiscite. Even so, they chose a secular and democratic option. They said, here is a state which recognizes that sovereignty vests in the people. And also, as your lordship said in Indira Nehru Gandhi, that this shared sovereignty is really a system of checks and balances. Equally, it is so between the center and the state. So Article 370 also reflects a system of checks and balances, central power and the power of the state of Jammu and Kashmir. Because the people are never completely excluded from any process, although they have entrusted their sovereignty. This is what the judgment says. So the checks and balance system is what expresses the political sovereignty so that nobody encroaches. So Article 370, in that sense, the will of the people of J&K permeates every part of Article 370. 371 and 371 survives. It is not, I do not endorse the view that the whole article has come to an end. 371, the concurrence, and I'm not saying it's binding. What Iyengar's speech is certainly not binding, but it reflects the fact that despite there being a titular monarch, the power of concurrence, even when there was no state legislature, was given to the largest party because it was a democratic step. And that is why 371, both for concurrence and for consultation, the state government is emphatically defined as a governor advised by a council of ministers. Even the CO 272 says that. Whether by mistake or what, I don't know. So a governor who is not advised by a council of ministers is not recognized by 370. And therefore, any CO issued during a period of president's rule is simply not competent. Actually, I checked. In 70 years, all of 5 COs have been issued during president's rule or governor's rule. 1 in 1986 and 4 extending the term of presidential proclamation in the year between 90 and 96.
What's the number of the 1986 CO?
129. CO 129.
And what was it relating to?
It was relating to, I think, the power under Article 249. It was a temporary resolution. and it was challenged, but it was never tested. What I want to say is this has never been tested for constitutionality. It was challenged in the Delhi High Court, but eventually it was dismissed as infructuous. So there is no ruling. So despite the peremptory terms of Article 370, whether a non-responsible government, a government not responsible to the state legislature, could exercise this power of concurrence has never been tested. And I'm saying it cannot be done. I could hand over the 5 COs. And therefore, Article 356, which is not covered by a non-obstantive clause, 370 is. Its special terms, its sui generis power to the state government is a power. And it is not a function that can be taken over by the central government. Function is a duty. Power is a discretion. It's a sui generis power given to a responsible state government and consciously given to a responsible state government. It cannot be taken over under Article 356, which is subservient to Article 370 on the sheer terms. And even a responsible state government's consent will not suffice for changing the terms of the article. It has to emanate directly from a constituent assembly. A constituent assembly signifies an exclusive agency, exclusively devoted and representative of the people of Jammu and Kashmir. Fully and exclusively. If a change has to occur, it has to occur by emanate. The recommendation has to emanate from an agency which is equal in mandate and stature to a constituent assembly. This is how the will of the people of Jammu and Kashmir on a principle of shared sovereignty is reflected in Article 370. And that agency, which must be equal, today there is no constituent assembly. After 57, there is no such agency on the horizon. If it has to be contrived, it will either be through political will, as they say, the hour, if I may paraphrase, the hour may produce the means. Else, whether it can be contrived in terms of the existing constitution, I do not think Article 368 will apply. Because the terms of Article 370 is this article and Article 1 will apply. So the limitations are there in the article itself, but whether it applies or not, that's not what has been done. Some thought and sensitivity and democratic stirrings are required to think of an agency which could express this will. But one thing is clear, it cannot be any agency of the centre. It cannot be because a democratic pact is between two power centres of sovereignty. And this is not as though they're setting up their wills against Indian sovereignty. As part of Indian sovereignty, there's a checks and balances system. There's the state and the centre. So how can the centre exercise the power which has been given to the state? It's, on the face of it, it's absurd. So the constitutional intent is clear. It cannot be any agency of the centre. The will of the people of Jammu and Kashmir is integral to the mode of governance specified in Article 370. And a process which has systematically, with malintent, erased the will of the people can never legitimately affect Article 370. And their will has been systematically erased in this fashion. I'll quickly give the run-up. 20th of June, the governor's rule is imposed because and it is stated in the order that because one party has withdrawn and no other political party is ready to form the government. This is why governor's rule was imposed, not because of anything else, not because there was a security issue, not because the state was in any danger, because no political party was willing to form the government. Then what earthly reason had the governor to dissolve the House within 30 minutes of two agencies saying we are ready to form the government, two political parties? So 56 out of 87 MPs take a claim. The governor is not there. We cannot determine where the governor is, but we can inform him. It is on record that the secretary has acknowledged the WhatsApp message. He does not answer the phone, fax doesn't go through. He is informed on WhatsApp, and a public tweet tagging the governor is issued. By 8:16, this is done, and by 8:57, we are notified that the House has been dissolved. What earthly reason has a governor to dissolve a House when governor's rule was imposed only because no political party was ready to stake a claim, and when political parties are ready and willing to stake a claim? What business has the governor to say, I'm not here, I'm not there? Then in this state of affairs, there is a proclamation of president's rule, and the president usurps the power of the state government under Article 371. It is not permissible under Article 356 because it only allows them to take over the functions of a state government, not sui generis powers, protected by a non-obstant clause. And what need has a power? He has executive powers to do whatever has to be done on a regular basis in a state government. And temporary legislative powers. Where is the need for this extraordinary power? It is not contemplated. And then we are told the situation was not okay for elections to be held. I mean, that situation must only be attributed to the governor and the president. Because until then, the reason was that no political party is coming forth. So this, I'll finish. So this is malice and this power under Article 356, which is really subject, legislative acts there are subject to a post-appraisal by the state legislature. This power is ironically used to destroy all possibility of a legislature. So the people of Jammu and Kashmir don't have a legislature when the act is contemplated of abrogating Article 370, and it is ensured that they do not have any future legislature either. And my friends want your lordships to believe that this is an expression of the will of the people of Jammu and Kashmir. My lords, this is, a self-proclaimed agent through a series of proxies, strangling the principle and telling your lordship this is not murder but suicide. This is really bad. And this CO272 is not only legally untenable because of what I said about Article 371 and the sui generis power. Only one page I want your lordships to see. There is this public functionary, volume 13, page 435.
Of the documents?
I'm aware that strictly a newspaper report is not evidence. It is not evidence in the sense that you cannot base a criminal conviction on it. But when a public